Hello and welcome to this episode of the Working Life podcast, the podcast of the Institute of Employment Rights. I'm Nicola Countouris. I'm a member of the Institute of Employment Rights. I'm also a professor here at UCL Laws. And today I have the great pleasure of hosting Lord Hendy KC, member of the House of Lords, also an honorary professor here at UCL Laws. Hello, John.
Good afternoon.
And we are here to discuss and talk about the Employment Rights Act that was approved in 2025 in December last year, a significant piece of legislation. We probably need to have more than one podcast to go through the detail of what the Act has introduced in the UK labour law statutes. But this is just the first chat to talk about whether it's a game changer and perhaps also what's missing from the final cut of the Act.
Well, I think before we get to what's missing, it's worth pointing out that the TUC published only yesterday an assessment of the Act in which they point out that their estimate is that 18 million workers will benefit from the new rights or extension of rights provided for in the Act or the regulations which will follow the Act. And it's also worth saying, a matter of particular interest to labour lawyers like you and me, that the Cambridge Centre for Business Research has published this year an assessment of the international standing of UK labour law in comparison to the legislation on worker protection elsewhere in the OECD and in the EU. And their conclusion is that the Act has significantly extended protection, worker protection, in comparison to the OECD and the EU averages. Have to say, however, that we're still 13 percentage points below the OECD average for worker protection and 19 points below the EU average for worker protection. So there's still a long way to go, but nevertheless, all advances are to be welcomed.
Absolutely. I think there are certainly important advances made in this Act. There is still a gap by comparison to our neighbours. There's some particular areas on which this Parliament could perhaps focus, things that didn't make it into the bill, into the Act, and would give some easy opportunities, low-hanging fruit, in order to move the bar even higher.
Well, I don't know whether you describe them as low-hanging fruit, but certainly, the Campaign for Trade Union Freedom and a number of trade unions are calling for a second Employment Rights Act in this Parliament to make good what they see as deficiencies in the Act that's just passed. So we could perhaps just highlight some of those things. The first and obvious one is what the labour lawyers call worker status. Yeah. That's to say the legal standing of those who work for other people. And there's various categories in UK law. We haven't obviously got time to go into them. The most obvious one being employees, and then you've got self-employed and fake self-employed, and what the labour lawyers call Limb B workers and so on. The thing is a complete mess because some rights go to employees, some rights are shared with Limb B workers, and some rights are denied completely to the self-employed. And it does seem to me anyway, much of like putting the cart before the horse. Yeah. If you decide to have new or extended rights without being sure which category of worker they're going to go to. So the Labour Party in 2021 published a green paper called A New Deal for Working People, very extensive, transformational outline of the industrial relations legislation that was required. And this act was meant to put into law those proposals, but in fact it's been watered down over time. And one of the proposals that the Green Paper contained was that there should be a single status for workers. In other words, all workers would be entitled to all rights from day one, except for those who were self-employed, genuinely in business on their own account. When I say all rights from day one, of course, we recognise that some rights are cumulative. You don't get 6 weeks holiday after your first day of work. Obviously, you've got to work up to that. But in principle, you would be entitled to holidays with pay from day one. It's just the extent of it would be accumulated over time. So the Act doesn't deal with worker status.
No,
it doesn't solve the problem. And one of the complaints now of the unions is that the roadmap, which the government have published and updated, I think the last update was the 8th of December last year, doesn't contain even a proposal for consultation about worker status.
Right.
So by the time we've had the beginning of the consultation, got to the end of the consultation, seen what the recommendations are, and then seen the shape of the regulations which are intended to put those recommendations into effect, we are a long way away from resolving the problem of worker status.
That's a big question mark. And any other obvious omissions or less obvious omissions?
Well, the next one is, to my mind, and there are four altogether, principal ones. The next one, to my mind, is collective bargaining.
Yes.
There's no mechanism in the Act for the government to institute a means of conducting collective bargaining between workers and employers, or unions and employers. And collective bargaining, particularly on a sector-wide basis, that's to say a particular industry or a trade, was the traditional way in which British terms and conditions were established, certainly throughout the 20th century. I mean, in the late 70s, we had over 80% of workers who were covered by a collective agreement, usually a sector-wide collective agreement, but often with enterprise bargaining or bargains with particular employers on top of that. But now, because of the policy of the Conservative governments in the early 1980s and various other factors, outsourcing, export of jobs overseas, privatization, and so forth, the rate of coverage by collective agreements is, in my view, I've done some research on this, around 25%. So 3/4 of British workers don't have the benefit of a collective agreement. Now, that's important because the absence of a collective agreement means that employers unilaterally decide what the terms and conditions are. So if you go for a job, there's no chance of you negotiating what the rate of pay is or how many hours you're going to do. You're told what the offer is, and you either accept it or walk out and try and find another job. So it's very important. Collective bargaining is really the only way that workers are going to exercise their voice. They have to do it collectively. It's the only way they have strength. And extensive collective bargaining has been shown all over the world to diminish inequality, to enhance, to eradicate poverty, and so on. It's got many economic benefits, and in particular the benefit to employers that it prevents undercutting
Yeah.
on labour costs. So that is a problem with the Act. No mechanism for extending collective bargaining. It's true that the Act does provide for a negotiating body for adult social care workers and a negotiating body for school support staff. But anybody who's read those provisions would come away convinced that this is not true collective bargaining. There's an opportunity for negotiating, but the fact of the matter is that the Act says that this does not constitute collective bargaining, and ultimately the government has got the power to override whatever the parties agree and substitute the government's view if the parties don't agree. So it's not really a collective bargaining. But as I say, the real problem is that there's no mechanism to extend it, even if it was collective bargaining, no mechanism to extend it to other workers.
Fair to say it's not a blueprint for a second bill.
No.
So worker status, collective bargaining. So you mentioned that there are 4 in total, so 2 more. What's the third one?
Well, the third one is concerns industrial action law.
Yeah.
The Green Paper, a New Deal for Working People, said that industrial action law in the United Kingdom should comply with the international standards ratified by the United Kingdom. Not international law generally, but only those provisions of international law which the UK had ratified. And they are, well, we don't need to go into the details of them, conventions of the International Labour Organization, provisions of the European Social Charter, and so on. And the problem is that the United Kingdom's been in breach of those international standards for a very long time, since at least 1989. And we know that not because it's the view of experts like you and I, but because the supervisory bodies, the peak institutions of those international organizations have declared on every occasion that they've considered UK compliance with their respective international standards. They've come to the conclusion that the UK is in breach. So it's very important for the rule of law that the United Kingdom should comply with its international obligations. A very topical subject at the moment, of course. But the next question, of course, is to ask, well, in what respects are we in breach? There are a considerable number where the United Kingdom fails to meet its international obligations. And I think the most obvious ones, which the Act does not deal with, are the requirement that there should be a positive right to strike that every individual worker should have, which would bring with it protection against dismissal or detriment for taking industrial action, other than loss of pay, of course. The Act does do something about extending protection for dismissed strikers, but it's limited and it doesn't go as far as the international obligations require. And the other standout aspect is that we have no protection in this country against secondary action. That's to say that workers taking industrial action in support of other workers, not necessarily against their own employer, but against where other workers are taking industrial action against their employer. That's secondary action. We have no protection. International law has made absolutely plain that it's a requirement for the UK and all other signatory countries to provide protection for secondary action.
And that's also vital to revive sector-level collective bargaining, isn't it?
Absolutely.
3, there's a fourth big omission.
Yeah, the fourth area where the Act does do something but doesn't go far enough. And that's the issue of remedies. Yeah. As has been said many, many times by judges in courts, rights without remedies are things writ in water. I mean, they're worthless. And we've got a major difficulty in this country with remedies for breaches of rights. First of all, there's the general point that litigation is really no substitution for negotiation. And what the Act does is to build on a feature of UK labour law, which has been present for the last 50 years, which is namely that workers' interests should be protected by their right to complain to an employment tribunal for breach of the rights. That means that the obligation is on the worker to pursue a remedy in effectively a labour court. And many of us have taken the view, the labour law community takes the view that negotiation is a far better way of resolving these things than litigation. And we've got some major problems in this country, one of which is that the tribunals are absolutely overwhelmed with work at the moment. Cases now are being listed not for 2026, but 27, 28, and earlier this week, a colleague of mine in my chambers was telling me that she's got a case that's been listed for 2029, which is
justice delayed.
August 2029, which is 3 years, 8 months from today. I mean, that's extraordinary, and that accounts for the backlog. I mean, it's a big case, 15-day hearing, but nevertheless, I mean,
it must be an important case.
Yes, but still, I mean, these cases are meant to be heard quickly, speedily, and so on. And if you've got a relatively small case, you haven't been paid your holiday pay, or you find out that over the last 6 months or so your wages don't measure up to the national minimum wage or something, you don't want to wait a year or 2 years to get your money back. There is a yet further problem that research has revealed, namely that even those employees who win a financial award in an employment tribunal don't necessarily ever receive the money. Something like a third of successful applicants don't see a single penny of their award. Employer goes bust, changes names, employer can't be traced, or whatever the reason. And there's also the difficulty that to enforce an employment tribunal award, you've got to go to another court. You have to go to the county court to do it. And most workers are just give up the ghost. That's the truth of it. Of course, trade unions are there to represent workers, but they haven't got the resources to deal with the tens of thousands of cases which there are every year, and the tens of thousands of extra cases which could follow the Employment Rights Act. But
it reminds me of Bob Heppel's expression that rights without remedies are just paper tigers. There's no deterrence there and no justice in the end. Can I ask you, as remedies stand and have been partly reshaped by the Employment Rights Act, albeit to a very minimalistic extent, do you think that the reoccurrence of some of the big scandals that we've had, like the P&O fire and rehire scandal a few years ago, is likely, or what is the status?
Well, there are specific problems in particular areas. First of all, let's just say on the plus side that the Act is going to establish a Fair Work Agency, which will have the resources to take up cases on behalf of individual workers. The problem there is, what will be the resources of the Fair Work Agency? Yes. Could it possibly take on 46,000 cases? I very much doubt it. And even if it did, where's the person power going to come from to represent these workers in tribunals and so on? So there's that is a step forward. What we really need is to go back to the wages inspectors, or what they have on the continent, labour inspectors, to go around like factory inspectors to take up cases at the workplace. But you ask about scandals like the P&O Ferries scandal, where 800 odd seafarers were sacked by text message at 7 o'clock in the morning, and the employer, realizing that, obviously, or calculating that these would be unfair dismissals and that the sacked workers would win in an employment tribunal, and realizing too that it was in breach of the requirement to consult over collective redundancies, the employer resolves that issue by bringing in cheap labour to replace them, all calculated beforehand, and paying off all workers the full extent of the maximum awards under the current legislation. Now, that will be more difficult after the Act, because one thing the Act has done is to lift the statutory maximum for unfair dismissal. So it will be very difficult for an employer to calculate what the maximum award would be if all 800 of its staff brought unfair dismissal claims. But it could make a fair job of it. One of the things that the Act doesn't do, however, is to allow a trade union to go to court and get a court injunction to force the employer either not to sack the workers or to consult collectively over redundancies. I moved an amendment in the House of Lords to provide that there should be such a remedy, but the government was not amenable to that. And there's another area too where where access to an injunction would have been beneficial, and that is the trade union right to see its members or prospective members on the premises of an employer. That's a great right that's been established under the Act, but the remedy for it is simply a fine on the employer if it refuses to comply with an order to grant access to the union. And once again, the government was not amenable to the possibility of an injunction being granted to compel the employer to provide the access which had been ordered.
Fines can always be costed into whatever calculus the employer has done in order to keep the unions out, in order not to grant the rights that they're entitled to. So it's worker status, collective bargaining at a sectoral level, industrial action legislation, and the important issue of remedies. Can I ask you, as a closing question, you're a member of the House of Lords, and of course you said you were very active in presenting amendments that sought to improve the final makeup of this important piece of legislation. It has to be recognized as you did. But there were other peers in the House of Lords that actually had a completely different agenda, and actually were extremely influential and played an important role in watering down some of the initial commitments that were present in the bill as it was first presented. What is your take on this perhaps constitutional question as well as labor law question?
You're referring to the Conservative Party yes. in refusing to go along with the Act as brought from the Commons. This is well after all my amendments have been rejected, by the way. My amendments were intended to restore to the bill as it then was the important measures that were in a New Deal for Working People, but they were all rejected. So we got to a stage where the bill had been passed by the Commons, but the House of Lords refused to accept a number of aspects of it. They passed amendments which were then sent back to the Commons, and Commons rejected them, went back to the House of Lords, more amendments passed, back to the House of Commons, and so on. A process called ping pong. Yeah. They did it 3 times and ultimately conceded that it was a hopeless task. Constitutionally, I mean, is very unsatisfactory. The House of Lords is, and I'm a member of it, totally undemocratic. It consists either of hereditary peers or peers that have been politically appointed, which is no way to conduct a democracy. And the idea that such a upper house can refuse a bill passed by the elected membership of the House of Commons is just utterly untenable. So it wasn't forced to a constitutional crisis, but and certain concessions were made by the government.
For example?
Well, one of the concessions was that on unfair dismissal, which are the Commons had originally said should be in line with a New Deal for working people, the right to unfair dismissal should be available from day one of employment. The government, however, introduced its own finesse on that by saying, well, that's okay. They can have the right not to be unfairly dismissed from day one, but we'll institute a mandatory universal 9-month probation period, the details of which we'll publish in regulations, which therefore will not be on the face of the Act, so you can't see what they're going to be. The House of Lords ultimately refused to accept even day one rights modified by a 9-month probationary period, and said no, there'll have to be a 6-month qualifying period before you can bring a claim for unfair dismissal. As it happens, I think that is probably preferable to a 9-month probationary period. But it did appear as if the government were making a concession on that. I don't know whether they ultimately shared my view that it was worse for workers.
It would have depended on the detail of the regulations on the probationary periods.
Well, it would, but one thing we can be clear of, the idea of a 9-month probationary period applying to every employment. I mean, most employments don't have 3 months probation, let alone 9 months.
That's definitely more than the OECD average, as you were
absolutely.
saying before.
Absolutely.
Well, John, thank you very much. That was extremely insightful. Tremendous pleasure to have you here. And thank you very much from the Institute of Employment Rights and from our audience. Thank you.
Great.